Wait, everybody, wait, we're not going yet.
Oh,
I
okay.
had to get the live stream going.
Oh, okay.
Jumped the gun a little bit here. Okay, this is JLLJ Development LLC and Lansing Future Development 2 LLC versus Kuwaitan Casinos Gaming Authority, docket number 21-189CB. This is the time set for hearing on the defendant's motion to dismiss, which is a motion for summary disposition. And now I'll take appearances. First for the plaintiff, please. And appearances for the plaintiff, please.
Go ahead, Andy.
I'm sorry, Andrew Broder and Michael Perry for the plaintiffs, Your Honor.
And Mr. Broder for the plaintiffs.
Yes, Your Honor, I for some reason, I'm having some trouble with the sound. I checked before and I was fine here, but I hope it just improves. But again,
Yeah.
Andrew Broder for the plaintiffs.
It is
Can you
better
hear
right
me
now.
okay?
Yeah, no, it's better right now, but when you were speaking before, I could see it was going to be a problem.
Okay, hopefully it's improved now.
Yes. Okay, and for the defendant, please, for the record.
Jeffrey Rasmussen for the defendant.
All right, then this is the defendant's motion. Mr. Rasmussen, you may go ahead.
Thank you, Your Honor. What we have here is I believe, a fairly straightforward sovereign immunity argument. We've got contracts that were, I'm getting a lot of feedback. I'm not sure if the court is.
I'm back.
I'm not.
I'm all
I'm
set.
not
not.
kidding.
Okay, bye.
What we got is a fairly straightforward argument regarding sovereign immunity. Contract at issue here does not waive the tribe's sovereign immunity from suit, and therefore the case has to be dismissed. This is not a discretionary issue. It is a matter of jurisdiction. The court does not have jurisdiction over the tribe and therefore must dismiss. There's two separate reasons why that is the case. The first is the tribe's sovereign immunity in the contract at issue does not waive jurisdiction into the state court. What it waives jurisdiction into is the federal court. And that is an intentional and usually heavily negotiated provision in a contract regarding tribe. Tribes generally don't go into state court. And many parties that they contract with don't go into the tribal court. And so those are the realities we deal with in these areas of tribal law. So what we've got here is a contract that says the court, the federal court is the court. And normally what one would see in a contract like that, and what would be certainly what you would expect an attorney to do, is to say, well, okay, what if the federal court doesn't have jurisdiction? What are we going to do? Because we all know we can't consent to federal court jurisdiction. In this particular case, for whatever reason, whether they just couldn't come up with a solution of a secondary forum, or for some other reason, they did not provide a secondary forum. What you see standardly in many of these sovereign immunity cases is that there is somebody who, or there is a provision in there saying, but if the federal court doesn't have jurisdiction, then we consent to some other court, or then we'll go to arbitration or something like that. We don't have that here. So the sovereign immunity waiver really couldn't be any clearer about this. It says federal court, and we can't go to federal court.
Excuse me, Your Honor, I can't hear what's going on.
Who said that?
What was that?
We're having a definite
May I
problem,
speak?
and I think It's on Mr. Broder's end. First it was his audio and now he's frozen. And I think he was interrupting to say he couldn't hear. We'll wait for him to unfreeze.
Okay.
There. Mr. Broder, were you saying you couldn't hear?
And I'm having trouble with this.
Well, this isn't working. So what do you want to do?
Your Honor, may I call in and listen and talk that way? Because I've done multiple Zoom hearings in the last year and I've never had a problem, and I don't know why we're having a problem today. There were some storms that came through the area earlier and maybe the internet's unstable for that reason.
Okay, so Mr. Broder, if you're going to do that, would you just do me a favor? Leave your device connected to my Zoom hearing and mute it though, mute yourself so we don't get feedback, and then call in. So that way I can see you and then I can hear you through the phone.
All right, very well. I'll do that.
We'll wait. I'm sorry, Mr. Rasmussen, to have this interruption for your argument, but we'll wait just a moment here for Mr. Broder then to call in.
Okay, thank you.
And for everyone else that's not an attorney arguing today, I don't take offense that I muted you. You know, just a little bit of noise on your end can cause interference and feedback for the attorney who is speaking. Here you go, Mr. Broder, I'll let you in.
Your Honor, I'm connected by phone. Can you hear me?
Yes, I can.
All right, good. I'm sorry for the logistical problem. I just don't know what the explanation is other than what I said before.
Yeah, well, it happens. I mean, this is the aggravation with Zoom. It's a wonderful convenience, especially with attorneys all over the place, but it can also be just nothing but a headache. So apologies again, Mr. Rasmussen, if you could pick up where you think you left off.
Yes, Your Honor, thank you. So the contract itself limits to the federal court. And then beyond that, and again, the contract could not be any clearer that this is a non-recourse loan and a non-recourse investment. And that the contract says in no way, shape, or form is there any right to any recovery other than from the profits from the casino. And that could not have been more clearly written. And what we have here, and one of the things that I must say really bothers me about this case is the tone that the plaintiff is taking here of basically calling the tribe cheaters. It's almost like they go everywhere except using the word Indian giver. And that's not acceptable in a court of law to have that tone of the tribe is trying to cheat us. The tribe is trying to renege on its deal, because that is not the case. What we have here is an investor who invested less than $9 million and now says, well, we should get $124 million. If the tribe wanted to go and get a loan for $9 million that was going to have to be repaid, it would not be paying that type of interest on it. No one would even suggest something like that. And they knew what they were doing. They invested $9 million, non-recourse loan, and now they're the ones trying to cheat the tribe by saying we get what we were going to get if this had gone through. So they agreed repeatedly that this was a non-recourse loan, that the only source was from the profits from the casino. So now in their response brief, they assert that they have the right, not under the contracts as they pled, their claim is under the contract. So paragraph 15, paragraph 17 of their complaint defines what their claim is. It's a claim under the contracts, which they define as the JLLJ contract and the Lansing Futures contract that were executed years ago. So now they come back in a response brief in a court that doesn't have reply briefs and says, oh, actually, we're suing under the notes. We're not suing under that. The problem with that, though, is that, first of all, they're not suing under the note. They're suing under the contract. And the contract, so that's their attempt to avoid the fact that they agreed not to come into the state court in the contract they sued on. Is they said, well, now we're suing under the note because the contract wouldn't let us come into this court, so we're suing under the note. Their complaint makes that clear that that's not true. Second, though, and making it really, really simple, I think, is that the notes that they claim that they're suing under specifically say also, as the contract does, these are non-recourse, and their own complaint in paragraph 42 says that they acknowledge in their own complaint, this is their own pleading, that the notes are subject to the same terms and conditions as the contract. That I view that as them pleading themselves right out of the court because they're agreeing that yes, all those limitations within the contract are within the notes themselves. The other thing then that they come back with in their response is to cite to a bunch of cases where other tribes have sovereign immunity. And it wouldn't be hard to do here in this particular case. It wouldn't have been hard to do if the tribe had agreed to it. But that's the heavily negotiated provision in a contract like this is, what are we going to do as far as waiver of sovereign immunity? And what we've got here is we're not going to waive immunity to the tribe's funds, to Kewaudan's funds. We're only going to waive the immunity to the profits that could be generated from this casino. And so when we've got a contract that has that subject, that limitation in it, they're trying to sue outside of that. Those cases that they cite to where somebody has waived sovereign immunity, where a tribe has waived sovereign immunity, I think illustrate the point that we're making, which is this particular contract is judged by the language in this particular contract. In this particular contract, the language could not have been any clearer. And they know what they did. They entered into a contract where they put up the $9 million in exchange for, if this worked out, they were going to get very wealthy. And they agreed to that, and now they don't want to live with their agreement. So in our brief, just want to briefly note that we discuss in our brief that Kewaudan has sovereign immunity from unconsented suit. The plaintiffs don't dispute that. That it has to be decided as a threshold issue. The plaintiffs don't dispute that. That it has to be that the plaintiffs have the burden of proving it by a clear and unambiguous waiver of sovereign immunity. The plaintiffs make a nominal argument on that issue. They cite to one case where the court, Supreme Court said in a case, we don't have to reach that issue because the tribe is the party who this could be construed in favor of. And so they said, we don't have to decide whether when we've already got the canon of construction for construing a contract in favor of the tribe, whether we have to also apply another, the same thing again, because the other party drafted the contract. The sovereign immunity cases, there are literally hundreds of them, and we cite a number of them in our brief for the proposition that a plaintiff has to prove by a clear, unambiguous waiver. Anything that is ambiguous, anything that is not clear, then the claim can't go forward. Finally, the other primary issue that we raised is that each of the claims has to be decided on its own. And so when we had a claim on the contract as they pled in the complaint, then they can't also plead a bunch of off the contract claims. The waiver in the contract to the federal court was for claims on the contract. Here they're trying to then assert all sorts of other claims off the contract, court-related claims, other claims off the contract. Contract are equitable claims, claims for equitable liens, and those, you have to individually analyze those, and those are just simply out. Their new claim that they're claiming under the note is out because it explicitly says it's a non-recourse loan. And the claims under the contract, as I understand it, they're not really disputing that they've got a waiver under the contract anymore. They just don't have a waiver under the contract for this court. But to the extent that they're making any other claims outside of that, those have to be dismissed because they're not contract claims. So that's the gist of where we are. Again, if the tribe wanted to loan or to take out a loan for $9 million, it would not have to go and go to some private investor who then would say, well, okay, yeah, we'll put up $9 million, but if this all works out, we get $124 million back. That's just ridiculous. And for them to come in and make that argument and then call the tribe all sorts of names and say the tribe is trying to renege on this deal, I think is beyond the pale of what would be proper argument in this court. But they knew what they were doing. They agreed to it. Now they don't want to abide by their agreement, which was, this is a non-recourse deal. You guys put up the money. If it works out, we all get rich, but it didn't work out. And so that's why the claim has to be dismissed under the contract, because that's what they.
All right, thank you. Mr. Broder?
Thank you, Your Honor. I'd like to begin with a personal observation, if I might. I want the court to know that, unlike Mr. Rasmussen, I haven't been litigating cases against Indian tribes and instrumentalities on one side or the other for very long. It's a fairly new endeavor for me, but I can tell Your Honor that during the last 3 years, I've been immersed in the field and I've read, I imagine, hundreds of decisions involving tribal law. And I have been rather stunned and troubled by the extent to which, in all of those cases, Indian tribes or their instrumentalities try to avoid the consequences of their contracts by distancing themselves from sovereign immunity waivers that they've given to induce parties to enter into those contracts in the first place. Frankly, I have never read a single decision in which an Indian tribe or an instrumentality of the tribe has conceded a waiver of sovereign immunity. There might be such a case out there. I simply haven't seen it. The case before Your Honor today is no different. You know, in the introduction to its brief, the Gaming Authority says that it has sovereign immunity from the, quote, unconsented suit, and that my clients do not allege and would have no basis for alleging that defendant provided a waiver of immunity in the Michigan State Court system for any of plaintiff's claims. That's a direct quote. Frankly, Your Honor, I find that statement to be neither factually nor legally correct. And it is why I placed right at the front of my brief, right in the introductory section, the waiver upon which the plaintiffs rely in this case. If that waiver, coupled with the representations and warranties of the Gaming Authority as to its validity and enforceability, is not effective, then I cannot imagine how any waiver would ever be effective. Mr. Rasmussen says to the court that this matter is straightforward, and I agree. I think anyone reading that waiver that they gave in the promissory notes would be compelled to conclude that they waived sovereign immunity not only in the federal court system, but also in the state court system. For one reason or another, the Gaming Authority seems to want to ignore what's in the notes, but they're bound by the notes. The transaction documents include the contracts and the notes. When Mr. Rasmussen says to the court that the contracts are only the development agreements and somehow the notes don't have anything to do with this, that's just flat out wrong. That's a misstatement of fact, and that's a misstatement of law. The transaction documents and the promissory notes are all part of the parties' contracts. It's specifically indicated not only in the transaction documents, but also in the notes. And I would point out to Your Honor that if you were to look at the promissory notes that I attached to the complaint, the ones that the plaintiffs are suing on, you will find that in the first note, there is a specific reference to the development agreements, and there's no reference at all in the other notes to the development agreement. Those notes stand on their own, and they're part of the parties' contracts. And without belaboring the point, because I know Your Honor has read the briefs, those notes indicate that the Gaming Authority has waived sovereign immunity, not only for the federal court system, but the state court system, has consented to be sued in federal court and in state court. And indeed, those documents say that going to the tribal court is only a measure of last resort. How the Gaming Authority can, in a brief filed with this court, say that there was never any consent to sue in state court when the promissory note says specifically that they consent to sue in state court is just beyond the pale. Mr. Rasmussen and I have an obvious disagreement as to that, but I believe that the clear language of the documents shows that the parties did intend and did negotiate that if there was a dispute, they could go into federal court, and if there weren't jurisdiction in federal court, then they could go into state court. That's specifically what the Gaming Authority said it would do, and it can't run from that promise and covenant. Now, the standard under which this court should review this motion, 2.116C7, it seems to me requires that the plaintiff's well-pled allegations in its complaint be accepted as true. That means, among other things, that there was a breach here in multiple ways, and that under the documents, as a consequence of the defendant's breach, the plaintiffs are entitled to all remedies under the notes and under the law to accelerate the notes and to pursue whatever remedies we have under the law. After all, the notes say that the waiver is as to, quote, any dispute, claim, or controversy between the lender and the borrower arising out of or relating in any way to this note or any actions contemplated to be taken in accordance herewith. I don't know how one could be clearer than that. As to the non-recourse provisions, Your Honor, I would suggest to the court that now is not the time to address the consequence of the non-recourse provisions of the notes. That is for a later day after discovery has developed the facts and theories in this case so that the court can understand the intent of the parties and what actually occurred in this case. Look, I wouldn't be sitting here arguing to the court that we should be able to exercise a litany of rights and remedies if the Gaming Authority had taken our money, had bought the land, had put the land into trust, and had built casinos so that there were revenues on which we could recover. The notes contemplated that if the parties performed properly, that's exactly what would occur. But unfortunately here, the Gaming Authority took our millions of dollars. Mr. Rasmussen admits it's more than $9 million, and they kept the money. They didn't buy the land, put it into trust, and build casinos, and yet they think that they can keep our money and that we're stuck with that outcome because of this non-recourse provision. I believe that when the court down the road, after the facts have been litigated and put into evidence before the court, and there is an opportunity to delve into the real meaning of the non-recourse provisions and how they fit into the kind of scenario that it exists here, the court will find that that non-recourse provision has nothing to do with limiting our rights and remedies under the facts as they exist now. Your Honor, I know that the court has read the briefs, and unless the court has any questions of me, that's really all I have to say. I believe this case should be permitted to go forward and the defendant's motion should be denied.
All right, thank you. And then Mr. Rasmussen, you get rebuttal time if you wish.
Thank you. Just briefly, Your Honor. I believe Mr. Broder just pled himself out of court yet again. He's saying that the time to figure out what the non-recourse provision means would be later after discovery. As the court knows, you only get to those sorts of issues if there's ambiguity. And if there's ambiguity, you have to construe it in favor of the tribe. So even on his best case scenario, he just pled himself out of this court because he's saying that there is ambiguity. So, but in our view, there's absolutely no ambiguity. The notes are not what are being sued under. The notes limit the claims that could be brought in the state court are limited to claims on the note, and the note is also subject, as they admitted and they pled in their complaint at paragraph 42. The notes include the same limitations on what assets can be used. There's just no assets that can be used. We all know how this is done, which is you go and you find an investor who's willing to put up the money, and if you can get an investor who's willing to put up the money, then you can give them a share of the profits down the road to compensate them for that risk. And that's what they did here. They took a huge risk. Getting a casino built in downstate Michigan, as they said in their complaint, their own complaint, is a hard thing to do. There were a lot of hurdles to get through. And that's why they had the big payday if it worked. And now they want the big payday, even though it hasn't worked. And they don't get that because they agreed that they would only get compensated from those profits. So the waiver of sovereign immunity, we believe, is clear and unambiguous. If, as Mr. Broder says, it's ambiguous, it still has to be interpreted in favor of the tribe because of the substantial case law that says that waivers of sovereign immunity have to be waived or have to be construed in front of the tribe, in favor of the tribe. But one last point I want to make is, yes, tribes all the time waive sovereign immunity. The fact that the case law is when the tribes believe they haven't is not indicative of the fact that tribes do regularly waive sovereign immunity. There's regularly suits where it's not an issue. It's only in this type of a case where somebody's trying to come back in and get something that they did not negotiate for, a broad waiver of sovereign immunity to get at all of the tribe's assets, that there's an issue. The plaintiffs here, we would note, are basically non-recourse entities also. And that's one of the things that is frustrating, is that they're complaining that the tribe entered into these non-recourse loans. But what we've got here are people who created these one-purpose corporations, put in whatever assets they wanted to put into those corporations, but we can't bring a claim against their corporations because the corporations are these single entity, single transaction entities. They know how to do the non-recourse for their benefit, and now they're complaining the tribe is doing it for its benefit, and that they agreed to it, and that they shouldn't have now, they say, because they want the big payday. So we are very frustrated with the language that they're using and trying to denigrate the tribe and denigrate the attorneys for a case where they knew what they agreed to and they need to live with it. So we would ask that the court dismiss this case.
All right, thank you. Well, as I indicated at the beginning, this is the defendant's motion to dismiss. It is in actuality a motion for summary disposition. According to the motion, it's brought under C4, subject matter jurisdiction, but that I could not find any briefing on that, so I'm not considering it under C4. It was also brought under C10 according to the motion, but it wasn't briefed again as a C10 motion, and it wasn't properly supported as a C10 motion, so I'm not considering it a C10 motion. What it is a C7 motion, which is how it was briefed, and that is that the assertion of sovereign immunity with respect to the tribe. So proceeding on those grounds, I think it would be wise to start with some guiding principles in this area. First, in order to relinquish its immunity, of course, a tribe's waiver has to be clear. A waiver can't be implied. It has to be unequivocally expressed. But even though it must be unequivocally expressed, and it doesn't really require the particular words sovereign immunity be used in order to constitute an unequivocal express waiver of sovereign immunity. I also learned from looking at the cases that were cited by both sides that the contract provisions themselves may suffice to work as an express waiver of sovereign immunity where in cases where those exact words are not used. So what I'm alluding to is the Bates Association case, the Michigan Court of Appeals case talked about the US Supreme Court case, C&L Enterprises, where the sovereign immunity was found to be waived. It didn't say the tribe expressly waives sovereign immunity, but it did, the contract said Oklahoma law would govern and that the Oklahoma courts had jurisdiction. So the US Supreme Court, as was discussed in the Bates case by the Michigan Court of Appeals, found that that satisfied an express waiver of sovereign immunity. I saw that again in a case that was unpublished. This is a Michigan Court of Appeals case from 2015. And as an unpublished case, of course, it's of little, it's not binding, but it was still informative along with the other cases that are binding. And that is Star Tickets versus CHUMASH Casino Resort. And it applied those same principles that you don't have to actually say we waive sovereign immunity, but the contract itself and the language of the contract may operate as such a waiver. So in that case, the contract contained the language that it was enforceable against any party in any court of competent jurisdiction within Kent County. And it also said the parties consented and submitted to the personal jurisdiction of Michigan for purposes of enforcing the agreement. And then finally, it also said the agreement was governed by the laws of Michigan. So again, those contractual provisions operated as an express waiver of sovereign immunity. So with those principles in mind, I would conclude that the turnkey agreements alone are far more expansive in waiving sovereign immunity than just section 6.3 alone describes. And of course, an entire contract always has to be examined. You can't just pull out one section and ignore everything else. So I examined the entire contract, and section 5.3.1.3 entitled Election of Remedies provides as follows, and this is a little long, but I think it's important. So it provides, notwithstanding any term or provision of any of the transaction documents to the contrary, developer may exercise any and all rights and remedies existing or available to developer under any of the transaction documents or under applicable law, including, without limitation, the rights and remedies of a secured party with respect to the operating profits and equipment under the tribe's UCC provisions. In the event developer shall elect to selectively and successively enforce its rights under applicable law or under any one or more of the transaction documents, such action shall not be deemed a waiver or discharge of any other right or remedy existing or available to developer under any applicable law or under the transaction documents, nor shall such action discharge any lien, encumbrance, or other security interest granted to developer under the transaction documents. Going on, section 5.3.3.2, cumulative remedies, provides the remedies provided for in this section 5.3 shall be cumulative to the extent permitted by applicable law and may be exercised partially, concurrently, or separately. The exercise of one or more remedies shall not be deemed to preclude the exercise of any other remedies. So that ends the quote from the agreement. So except for the non-recourse provision, which I will speak to in a moment, section 6.3, which expressly mentions sovereign immunity, is actually quite consistent with the very broad waiver in section 5.3 that applies notwithstanding any term or provision of any of the transaction documents to the contrary. Section 6.3.1 provides that any dispute shall be resolved first pursuant to applicable federal law, second pursuant to applicable state law, and third pursuant to the laws of the tribe if neither federal or state law applies. Further, it says that the parties designate the U.S. District Court for the Western District of Michigan as the forum for any litigation. It seems to me that we have an illustration here by what the plaintiff did as to how this language applies. The plaintiff followed it and adhered to that language in this case, giving federal law the first shot. The plaintiff filed suit in federal court. However, not a great surprise, the federal court found that federal law did not apply because there was no federal jurisdiction. There were only state law claims, and there was no doorway to federal court in the action. So the case got dismissed, and then this suit followed in an effort to apply state law. That's exactly what section 6.3.1 says, that any dispute is resolved first by applicable federal law, second pursuant to applicable state law. What could that possibly mean when if all you have are state law claims, you're never getting in the door or much past the door of federal court? It obviously means that you take a shot at federal court, and if that doesn't work because there's no applicable federal law, which there was not according to the federal court, then you go to state law. If you go to state law, you have to go to state court, because if there's no doorway into federal court, then that's the next option per the contract of the parties. So this suit followed in an effort to apply state law. Section 6.3.2 merely affirms that the waiver in section 6.3.1 applies, and then it goes on to affirm that it is an express and explicit waiver of sovereign immunity with respect to the gaming authority only, and that is the only defendant here, so not a problem with that language. So with all of that said, the applicable language in the notes is consistent with the turnkey agreement. The notes say, the borrower hereby expressly grants to the lender an irrevocable limited waiver of its sovereign immunity from suit with respect to any dispute, claim, or controversy between the lender and the borrower arising out of or relating in any way to this note or any actions contemplated to be taken in accordance herewith, collectively a claim. In furtherance of the foregoing waiver and with respect to any claim, the borrower hereby consents with respect to any claim to be sued in 1, the U.S. District Court for the Western District of Michigan, or 2, any court of general jurisdiction in the state of Michigan. And that ends the quote. It doesn't end the whole language in the contract, but it's the applicable language. It goes on to say, further, upon default, the lender shall have all rights and remedies provided in this note or in any other agreements between borrower and lender and applicable law. So I read that as the same broad and expansive express waiver of sovereign immunity that's contained in the turnkey agreements. The only thing that is remaining to be addressed is the non-recourse provision in the turnkey agreements. Section 6.3.3, procedural requirements is the title, provides that the waiver of sovereign immunity is effective only if every one of three conditions is met. And the third requirement limits funds to satisfy any judgment developer secures to the operating profits and the equipment. So that's the part where that limitation seems to fly in the face of the language in the other transaction documents that expressly and irrevocably waive sovereign immunity and grant the developer all of its rights and all of its remedies in the event of default. And that conflict has to be addressed. And I would resolve it with any of these three approaches. The first is that in the event, and this is section 5.1 of the turnkey agreement, in the event of a default under the turnkey agreement, that constitutes a default under all the transaction documents. And section 5.3.1.3 of the turnkey agreement provides under election of remedies, notwithstanding any term or provision of any of the transaction documents to the contrary, developer may exercise any and all rights and remedies existing or available to developer under any of the transaction documents or under applicable law. There is no comparable notwithstanding any other term or provision language with respect to the non-recourse provision. So that's one way of looking at it. That alone does not have to be dispositive because I think there's two other ways of looking at it. And the second way is that the plaintiffs suggest that the broader waiver controls over the limited waiver. And I agree with that. The cases that the plaintiff cites in footnote 13 are not exactly on point. However, I would suggest that unlike other terms in a contract, a waiver is an operative term. Once it's made, it's made. And that's unlike other contract terms that promise to do things in the future. A waiver is executed when it's made. So even though the cases cited by the plaintiff are not exactly on point, I think the concept makes sense when you're talking about something like a waiver. And it makes even more sense when you're speaking of an irrevocable waiver. So how could it be irrevocable if once you make it, it could be, it's made and it then could be limited or modified by a more limited waiver? That just doesn't make good legal logical sense to me. But of course, and this is the third reason, although it makes good logical legal sense to me, I know I don't make the law, but the U.S. District Court for the Northern District of California saw it pretty much the same way in a case with the same type of non-recourse language that we have here. And of course, that's not binding, but it is instructive and it's guidance for this court. And that's the JW Gaming Development versus James case. And that's Plaintiff's Exhibit I. In that case, the note had a broad irrevocable waiver and then another non-recourse provision that the tribe argued was a limitation on the scope of the broader waiver, just as the tribe has argued here. Relying on U.S. Supreme Court cases where a waiver of sovereign immunity was granted by statute, the U.S. Supreme Court ruled that where one statute grants a waiver of sovereign immunity, a different statute that granted substantive rights that the plaintiff was trying to enforce did not have to provide a second waiver of sovereign immunity. I think the district court's application of those cases in JW Gaming is sound, and I think it's persuasive. Once sovereign immunity is unequivocally waived and irrevocably, as here, the non-recourse provision did not have to contain a second waiver, and it did not have to meet the strict rules of interpretation that are applied to waiver provisions. There are two remaining issues in this case. I guess you could say two. One, I should have probably addressed at the beginning. the defendants, or the defendant rather, says that plaintiff did not plead a waiver of sovereign immunity. The plaintiff did plead a waiver of sovereign immunity in paragraph 6 of the complaint. And then the other issue raised by the defendant is that the defendant says that plaintiff has made non-contract claims that are not covered by the waiver of sovereign immunity. I think I've already addressed the sovereign immunity waiver as being express and broad and granting the lender, the plaintiffs, all remedies available at law. All of the counts in the complaint grow out of the transaction documents. There are other issues that the defendant raises with respect to the counts that are not strictly limited to sovereign immunity. I don't consider them adequately briefed or raised or addressed. For instance, in footnote 5 of their brief, the defendant seems to be making a C8 argument about count 10. The other argument is made in footnote 6. I just don't think it's adequately addressed or raised or briefed. And furthermore, I agree that this is not the time to address the consequences of the non-recourse provision or any of the contract provisions, because this is solely about sovereign immunity and whether there's been a waiver of sovereign immunity. So my ruling today is under C7, MCR 2.116 C7, and it is limited to the waiver of sovereign immunity. And I find, in fact, that there has been an express and unlimited, irrevocable waiver of sovereign immunity. And for those reasons, I am denying the defendant's motion to dismiss. And Mr. Broder, would you like to submit an order that just says, for the reasons stated on the record, it's denied under C7?
I certainly will, Your Honor.
Okay, then if there's nothing further for the record, that will conclude our hearing today. Thank you, everyone.
Thank you, Your Honor.
Thank you, Your Honor.